My name is Mark Whitney, and I started the LawNet 15 years ago. Today, half the attorneys in the United States have paid access to the syndicated database that resides at the centerpiece of our software, which is a proprietary browser, which you can get a tour of in other videos. Right now, I am going to show you the right way to search for case law. Let me quickly tell you first a personal story. When I started the LawNet 15 years ago, just at the turn of the century, just at the turn of the 21st century, I was a book researcher. Loved researching with books because I knew that I couldn't miss a case. The problem with books is the reference tools, the tools that were published to get me to those cases, only represented a partial index of the opinion, whether it was a head note or a key number or some other index, am juror, corpus juris secundum, whatever it is. These are all these man-made indexes that represent a small subset of the opinions that human beings wrote to refer me to cases. The good news was that as long as I followed the indexes, if I got Shepard's out and I followed and I looked up a statute, I could see the cases that Lexis editors found, citing my statute. I knew I covered the landscape. I knew I didn't miss anything, unless a Lexis editor missed it, or Shepard's editor missed it, in which case everybody missed that case. So if the opposing counsel is missing the case and I'm missing the case, well, we're even. But then computers came along. 1975, West introduced computerized legal research. And so that's 40 years ago. And the search engine indexes every word. So there are two reasons I started the company. The first one was I wanted to come up with a set of best practices for purposes of that would turn the process of legal research on the computer into an administrative process, into a simple retrieval process. So when we use the computer, we look for known opinions, we look for unknown opinions. Those are only the only two things we can look for. Known items of information, unknown items of information. If a statute is known to you, you just pop it up. Any idiot can do that, right? A person getting $10 an hour, you give them a citation or a series of citations, they can pop those things up. Those are known to you. But how do you reliably, find all the unknown items of information you want? Is there a right and wrong way to use the computer, a set of best practices? The other reason I started the LawNet is I saw West and Lexis and the way they did business. I just viewed these companies as bad for democracy. First of all, they're both owned by multinational corporations that operate outside the United States. And the whole idea of taxpayers paying for public information and then companies scooping it up and parsing it out in a very expensive way to attorneys, thereby creating a class system where people in large government instrumentalities and large corporations, those litigators, those researchers are able to see all the law from coast to coast. But if you're just using a regular workaday lawyer in a small to medium-sized law firm in your town, the man or woman who practices bankruptcy, divorce, criminal civil litigation in your local area, lawyers on Main Street, those attorneys typically can only afford to rent a database that shows them a small slice of the law. West and Lexis even referred to them as slices. So I wanted to come up with something that was affordable, under $50 a month, where any attorney could afford to see all the law from coast to coast. And when you go into a law library, it creates an optical illusion. The illusion is that there's a lot of law out there, but that's really not true. There are really only about 6 million cases that have been written by judges since the beginning of the Republic. That's not a lot. Most statutes have never been considered by a court. That's just a statistical fact. So with that as background, what I want to do here is just take a few minutes and explain to you how to think about
you're a computer database of judicial opinions, no matter what service you're using, Westlaw, Lexis, Fastcase, TheLaw.net, whatever you're using. I want you to know how to think about this tool that is a complete index of judicial opinions, because it's not a library, it's a database. And the database is comprised of language, right? And the language breaks down into two bins. A judicial opinion speaks in code, and it speaks in plain English. And by code, I mean, for instance, well, we came up with this equation: anchor plus filter equals hot list. Anchor plus filter equals hot list. What does that mean? Well, if you look at a judicial opinion, it is written in language, and if you're in the United States, it's written in the English language. But that language breaks down into two categories. Part of every judicial opinion is written in code, and the majority of it is just written in plain English. Let's talk about the different types of code that appear in judicial opinions. Anchor plus filter equals hot list. So I'm going to give you some different sample searches today, and I'm going to be using code to anchor our search queries, and then language to help filter the queries so that we end up with a hot list of opinions that we definitely want to read. It's very process-driven, and it provides a set of best practices that turns the business of looking for judicial opinions into a very scalable administrative task. So we have constitutional codes, and there is a right and wrong way to cite to the Constitution. In fact, there's only one right way, and there's an example, right? That's what makes it a code. We have statutory codes, right? That is the correct way, and it is the only way to properly cite to the criminal conspiracy statute, the federal criminal conspiracy statute, right? We have administrative codes. This is the correct way to cite to this title and section of the CFR. We have procedural codes, right? Now, you could sit there and enter probative or prejudicial and get a bunch of ambiguous results, or you could just anchor your query with the code assigned to that item of information driving your search, in this case, Rule 404B. So 404B returns all the cases in the jurisdiction you care about that contain at least one reference to that rule number, the number written by the people that created the code, and usually courts, in the case of procedural codes, or rules committees at bar associations or whatever it is, but they create this numeric code. 404B and elimine is a much better query. In fact, I would suggest it is the correct query, and that if you enter just words, that is wrong. Every legal research project starts with the black letter law, and I don't care what your research project is. It is driven by an item of information that is codified in a constitution, in a statute, in an administrative regulation, in a procedural rule of some sort. It might be a rule of criminal procedure, civil procedure, judicial procedure, administrative procedure, all these different procedural rules. It might be a local rule that you have to follow. And then we also have opinion codes. Lawyers, why, I don't know. Lawyers are not trained to think of a citation as a piece of code, but it's a very elegant, specific piece of code. In fact, our search engine, we have this smart box, and if you just enter a naked citation, it knows that you want to just look at that one case. You punch the citation in, click search, and up it pops. So there are 5 different codes that can appear in a judicial opinion, and I don't think there are 6. I think 5 is it. No matter what judicial opinion you're looking at, we have these codes scattered throughout. And then the vast majority of the opinion, obviously, is just plain English language. We have constitutional terms like ex post facto, Miranda rights, right? Unique nomenclature that can act as filters. Statutory terms, material false, sexual battery. We have administrative terms, scheme or artifice, excited utterance. Procedural terms, prejudicial, probative, again, excited utterance.
These terms can appear opinion terms: mortgage, foreclosure, predisposed, just regular English language. So when you anchor your query with the numeric citation created by a governmental instrumentality, that brings back all the opinions in the database. It's just a general list. You then add a filter. Hopefully, if your client is charged with murder, you have actually printed out the murder statute. So you have it sitting there right next to your keyboard, and you can look and see the number of the statute, and you can see this specific language, sexual battery. So the number of the statute and the term sexual battery are going to find cases in your state that construe the murder statute and also contain at least one reference to the phrase sexual battery. So that's how we look at the world here at TheLawNet, and you are certainly free to look at the world that way, no matter what database of judicial opinions you have to search. And we also make a distinction here between when we talk about legal research around here, we mean real legal research. There is a difference, again, when you look for items of information, you sit down at the computer to look for something, or you go into a law library. There are only two kinds of information you can be looking for: known items or unknown items. Known items of information you just retrieve, you just pop up. Unknown items of information require a process, a set of best practices, and that there is no set of best practices being taught at law schools. You go to law school, and Westlaw reps and Lexis reps and people at law school that teach legal research, they will teach you that you can use the word "and," but they don't say this is when you use it. Or they teach you that there is a within connector, or the word "or." We have all these connectors and all these operators and all these things that you can do with syntax, but they don't tell you the right and wrong way, when to use them, when not to use them. And that's exactly what I'm going to do right now. So let's go. Legal research best practices. Retrieve opinions citing your opinion for your point of law, right? So here's a query. We anchor the query with a piece of code, in this case, a case citation. We put, whenever we have spaces in a search term, as we have here with the citation, we put quotation marks around that term to force the search engine to find that phrase. And this is true no matter what database of judicial opinions you're searching, right? Westlaw, Lexis, TheLawNet, doesn't matter. So this query is going to find judicial opinions that cite your case for your point of law, right? Or we could take two anchors and combine them. This query asks for judicial opinions that cite your case and the statute. Why would we do that? Well, when we search judicial opinions, 90% of the time, we're talking about searching appellate case law. You're searching your state Supreme Court, intermediate level appellate courts in your state if you have them, the U.S. Supreme Court. So we're searching, because we're searching appellate cases, with the exception of the Supreme Court, your state Supreme Court, your primary federal circuit, when they write an opinion, it's usually three judges, however many judges you have in your state, right? At the federal level, the circuits have three judges. So the opinions on average are 3,000 words, and they resolve 3 to 5 points of law usually. So by asking the search engine to return only those cases that cite the statute, rule, regulation, constitutional amendment you care about, you are simultaneously weeding out all the opinions that cite your case for points of law you don't care about. And we call that a hot list. We call that a hot list. So if you want to see every case in your jurisdiction citing your case only for your reason, because you're working with a complete index of the opinion, every word has been indexed by the robot, right? Every single word. So if you know how to reach in and cherry pick just those opinions that cite your statute while simultaneously weeding out everything else that's irrelevant, that's a great query. And you have found everything. You've missed nothing. There's no human element involved like there was in the old days when West and Lexis editors were writing head notes and summarizing things. I mean, if you're looking at a case from 1972. In that case, those headnotes were written in 1972, and they haven't been touched since. So, and that was just a partial index of that opinion, and it was the best people could do when there were just books. John West started West Publishing back in the late 1800s. He bought opinions from courts and published them in books. In the 1800s, the only way lawyers could see opinions was to go down to the court and buy them. So John West started buying them up, publishing them in books, and then in the early 1900s, he got bought out by his partners because I guess he was kind of a pain in the ass. So they gave him $250,000 to go away, and he did. And then that company went on to become a $6 billion privately held company before it was sold to Thomson and then Reuters. And these reference tools that they created for helping us get to opinions that we never would have been. We would have had to read every opinion in the library, but for these partial indexes. Today, we have robots that read every word of every opinion, and all you got to do is know how to ask the question. It's nothing like looking for a needle in a haystack. It is a retrieval task that is teachable to anybody, and here we are teaching you. How about your citation, the case you care about, and any cases that contain a derivative of the word remand? Our database, most databases you can use asterisk or exclamation mark. Our database is the same. I prefer asterisk. It seems to work better. How do you retrieve an opinion citing a term within a specified number of a term? I've been doing a lot of support of attorneys for the last 15 years, a lot of speaking at bar associations. And this term right here, the within term, is the most abused of all Boolean operators. George Boole was a mathematician and algebra guy. And when we talk about Boolean searching, we're talking about building little equations. And so you should use a slash as a substitute for the word and or the word or, because search engines don't see the word and or not. Search engines are blind to those words, don't see them as part of the English language. They see them as technical terms that are used to accomplish certain things. So if I want to see cases that contain the phrase search and seizure, I replace the word and with, I say, give me cases that have the word seizure within 2 words of the word search. This also is an alternative way to ask the same question. You can have the W there or not. Now, I talk to people all the time. Attorneys will say, how do I ask for cases that have term A within 10 words of term B? And I always say to them the same thing. What if the case that is going to make or break you is 11 words away, and you ordered the robot to give you only those cases that contain 2 terms that are 10 words apart? So my point is that it stops being a process. That is an arbitrary decision to ask for 10 or to ask for within a paragraph or a sentence. Whereas what I did here, I have a specific reason for doing this. And a good search engine now, this is certainly true with Westlaw Next. I don't know about Lexis, but Westlaw Next and the THELAWNET, our algorithm already considers search term proximity, diversity, numerosity, and other factors. So if you just put the word and, like we did earlier, we had the citation and sexual battery or whatever it is, citation and false loan application. The algorithm already considers proximity, so you don't need to worry about it. It's going to give you the most relevant cases first, and proximity of search terms in relation to each other is a huge factor in determining relevance in a case law database. So let's continue. Retrieve single or multiple known opinions. As I mentioned, if you just enter a citation, our search engine knows that if you enter a citation without quotation marks, that you just want to read that case, and you're going to just pop it up, right? And if opposing counsel files a memo or a brief has 10 cases in it you want to find, just enter the citations one after the other, separated by a comma, click search, and you'll have a list of those cases right there. And you can save them to your computer, print them out, do whatever you want. Beautiful two-column printing. No charge for that. Is Westlaw still charging to print things? That's amazing if they are. They can get people to pay for that. Retrieve opinions by party names. Bush versus Gore. Just enter it. The case will come up. You will find other cases that have the word Bush someplace and the word Gore someplace. If you sort in alphabetical order, which you can do on our results screen, you'll also find other cases that have been published or unpublished that include a reference to the same party names, and perhaps those two parties are involved in the same controversy or case. And you'll see those as well. Retrieve opinions citing your statute, rule, or regulation, right? So when you sit down at the computer, the first thing you want to ask yourself, what is the item of information driving my search? Is it a constitutional amendment, statute, rule, regulation, case citation, rule? I got to learn how to talk again. I just had some braces, some adult braces, and I got those off, so I'm kind of like, just kind of figuring out how to talk again. But anyway, how do you retrieve opinions? And notice I use the word retrieve, like not research for, like we're just going to go out and get them, right? And this is all still information. Like the opinions you're looking for are unknown to you, and even when you go out and retrieve a list and you have your list of 10 or 11 opinions that match your query, you're still just dealing with information. It doesn't become knowledge until you, the attorney, look at the cases and determine the weight you want to give those cases. That's true whether you go to a law library, whether you're at a computer. It doesn't become knowledge until you assign an amount of weight that a particular opinion should have under the totality of circumstances surrounding the case or controversy that you are in charge of dealing with. So, if I want to find opinions that contain a reference to a statute, I just take that statutory citation and put it in quotation marks. If that's assuming there are spaces in the statutory citation. In many states, there's just a number assigned to the statute. There are no spaces. You just enter that number. Boom. You'll be looking at cases that cite that statute. The Florida murder statute, for instance, is 782.04. You would just enter that. You'll be looking at all the cases. There are about 1,200 of them. And then from there, you can add a filter, just add some plain language to get down to just those opinions that construe your statute for the reason you care about. When you have spaces in a statutory, in a statute, rule, or regulatory citation, you can decide that you want to replace those spaces. You're going to just substitute using the within connector /5 or W/5. Right? You can substitute, and by substituting the within connector, by just going /5, it solves for all these alternatives. So if your statute is mentioned in a list of statutes, like the final entry here on this slide, you're still going to find that case. If you have a judge who, for some reason, did not cite to the statute correctly, which is pretty rare, particularly at the federal level. But the point being that this one substitution solves for all these variables. So again, best practices. Everybody should do this. And this is the right way to do it. There is not another way. This is how you do it. Right? That's how you query a complete index. Retrieve opinions citing inclusive terms. Right? So if I want to find every case in our database or any database that includes at least one reference to the term unconstitutional anywhere in the opinion, I just enter it, click search, and search the whole country, and there I have a list of a gazillion cases, right? If I want to see opinions that contain a reference to the word unconstitutional and the phrase due process, that's how I fashion that. And you can use an ampersand, but for me, I like typing the word and out because it's just visually easier for me to understand the query when I'm structuring it. And also, notice I always use lowercase. That is also best practices. In many search engines, if you enter uppercase, like the word house, uppercase House, you might find only that. whereas lowercase is generic. It finds everything. So just always use lowercase, never use uppercase. Unconstitutional and cruel within 2 words of unusual. Remember, I'm substituting the slash for the word and. So I have a specific reason for doing that. It's not arbitrary like the researcher who goes, oh, I just want to see this word within 10 words of that word, right? That's crazy. That is arbitrary. It's going to lead to arbitrary results, and you're not going to be the smartest lawyer in the room. The smartest lawyer in the room at that deposition or that hearing is going to be the individual who just put the word and between their 2 search terms. Unconstitutional and citation. So your citation, your anchor, we got a filter followed by an anchor. Anchor followed by a filter, doesn't matter, right? We've got a piece of plain language and a piece of code, and we want to see those 2 things. And here's a situation, right? You're the criminal defense lawyer, and your client walks in the door, and lo and behold, that person has been indicted for committing a conspiracy to launder money. And if that is in fact the case, I guarantee you, in that indictment, you're going to see a citation to Title 18, Section 371, as well as Title 18, Section 1956, the money laundering statute. And those 2 statutes are going to rule your life for the next 2 years. So you're going to want to see all the cases in your primary circuit that cite to those 2 statutes, and that is how you do that. And you're going to find, 18 or 32 or 20 or how many there are. But that's it. That's your list. That's your database. That's what you have to work with for the next couple of years while you resolve that criminal case for your client. And the only thing that's going to happen different from that is within that 2-year period, 18-month period, whatever it is, maybe your circuit is going to write another opinion citing one or both of those statutes. So you're going to want to go back and check that. But that is the mother lode, and you're not going to miss anything. So you know you've got everything, right? Retrieve opinions citing alternative terms. Knife or stab, 2 words mean the same thing within the context of a particular murder case, right? So this query will find opinions that contain at least one reference to at least one of those terms. Does that make sense? Right? Here we go. I'm hitting you with parentheses, right? The only time you use parentheses to query a database is when you are grouping alternative terms. So this is an algebra equation where I'm saying, look, I want to find cases that talk about wire fraud, mail fraud, bank fraud, or tax fraud, right? And so there we are. That's what we're going to find here. This query that I just brought up, do you understand how it's conceptually distinct from the query prior to it? Okay, the first query asks for opinions that have the word fraud within 2 words of the term wire. The second opinion asks for opinions that have the word fraud anywhere in the opinion, the word wire anywhere in the opinion. So I'm going to get many, many more cases with the second hit, with the second query, and it's really not a good query because it's going to deliver ambiguous results. Whereas the first query is going to find me only cases talking about wire fraud, mail fraud, bank fraud, or tax fraud. Here's another case where I doubled up on these are analogous statutes. Here I've got 2 anchors which are similar. The first one is the false statement to a bank statute. The second one is the bank fraud statute. And so sometimes you have laws that are so close together that you want to see all the cases citing 2 or 3 laws. So you can just build a query separating those laws with the word or. If I had a third similar law, I could just add or and then add that anchor as well. If you have questions, if you want to subscribe, just go to THELAW.net. We've been there online at that address for 15 years. The funny thing is about this business, we probably don't talk to 85% of our subscribers. They go up online, they subscribe, and within 5 minutes they're up and running. We do not auto-renew subscriptions. Our robots will start dunning you to renew within about a month of the time your subscription expires. You have to make an affirmative choice to go up and renew your subscription. We don't auto-renew. We don't retain credit card information or anything like that. So it's still less than $50 a month. Subscription now is $575 of the whole year, flat rate, unlimited access, all 315 federal and state jurisdictions, statutes, rules, regs, and a lot more. Print all you want, search all you want. Never an upcharge, never an upsell. No distractions like you have with West and Lexis, where they're always trying to sell you other stuff. You know, they return all these gazillion results that have nothing to do with anything. If you have questions, call us toll-free, 1-877-452-9638, 1-877-4LAWNET, or email our all-points email, postmaster@thelaw.net. Again, my name is Mark Whitney, and we would love to have you as a subscriber. If you have questions or comments, give us a call, send us an email, let us know, and we look forward to taking care of your legal research needs. Thanks a lot.